litigation funding is often required in order to launch and run a representative action. So to start with, can you outline the representative action regime that we have in the UK?
Yeah, sure. So the representative action regime that we have here in the UK is really the closest thing that we have to the US opt-out class action regime. And of course, we have a bespoke regime for opt-out competition claims. So when we're talking about representative actions on this podcast, we're obviously talking about non-competition claims. And the representative action regime for non-competition claims is set out in CPR 19.8. And this was recently renumbered. It used to be known as CPR 19.6, but I will refer to it with its up-to-date numbering, which is 19.8. And the test in CPR 19.8 is a mercifully short one. And it provides that where more than one person has the same interest in a claim, the claim can be begun, or the court can order that it be continued by a representative who shares that same interest. So the key is whether the representative who is seeking to commence the claim as a representative action shares the same interest as representatives, i.e. other members of the class. And it's that same interest test which has received quite a bit of judicial attention in recent months and years.
So what does same interest actually mean in practice? What have the courts said around this in the actions that they've considered so far?
Yeah, well, it's previously been a pretty strict test, actually, and I think the reason for that is the consequences of an action being pursued and continued as a representative action are quite strong. I mean, this is an opt-out regime, so if an action is commenced and continued as a representative action, then the judgment will be binding on all class members unless a class member opts out. So that's quite a sort of big deal, and so the courts historically have been quite careful about ensuring that only the most appropriate cases qualify as 19.6 or now 19.8 cases. So we previously had that very strict test. Now, what we then saw with the Lloyd and Google case, which was a Supreme Court judgment, it reversed the previous decision of the Court of Appeal, which in turn reversed the previous decision of the High Court. So we did see some differences in view between the different levels of the court here, but the Supreme Court is obviously the highest court of the land, and that has now given a pretty definitive view as to what same interest means. And I think most people in the market feel that the Supreme Court, whilst it decided that the Lloyd and Google case could not proceed, at least when it came to quantum, on a representative basis, it largely relaxed the same interest test. And the way it described the same interest test as operating was to ask whether or not there is a conflict between class members. And that's quite an interesting articulation of the rule. So the Supreme Court felt that provided there wasn't a conflict of interest between class members, then the same interest test, subject to the judicial discretion, which I'll come on to in a minute, could be satisfied. So, for example, the fact that a defendant may have defences to a claim from some class members, rather than the class as a whole, did not preclude the same interest test being met. So, suddenly we are seeing a world in which you may have some differences between class members, and actually the case can proceed under CPR 19.8, provided that there is no conflict between them. So you can have differences. The key is to make sure that those differences don't result in a conflict between the class members. So that's the first way in which the same interest test was clarified, if not relaxed. The second way was when it came to damages, and I think a lot of legal commentators and I think a lot of lawyers had always felt that any claim for damages, by which I mean compensatory damages, could never be pursued under CPR 19.8. The Supreme Court had something to say about that. And as I say, whilst the claim in Lloyd and Google was held to not be one that could proceed under CPR 19.8, and in that case, Mr. Lloyd was seeking damages for data breach. So it was a particular type of damage that was being claimed. So whilst the Supreme Court said, no, we can't have that, what it did say is that there are various other types of case where you might well be able to seek damages. And the critical question is whether or not the calculation of those damages would require an individualized assessment. And so that's really where we are now with the law. The way I tend to see this now in the state of the law after Lloyd and Google, if in order to work out what damages are due to the class as a whole, you would have to interrogate the position of each class member, get on the phone to them. How did this affect you? And you therefore build your damages sort of from the ground up, or the bottom up approach, as the Supreme Court put it, in order to calculate what is due to the whole class, then that's not going to work. That's the individualized assessment that the Supreme Court wasn't happy about. But if in order to calculate damages to the class, you can apply a common method of calculation to class members as a whole, such that you don't need to interrogate the position of each class member, then it looks as if you can claim damages in a representative action. And another way of describing that is what the Supreme Court called the top-down approach. So you look at you apply a common method of calculation to look at what damage was suffered by the class as a whole. You don't need to get on the telephone, so to speak, to individual class members to work that out. And helpfully, the Supreme Court, Mr. Justice Leggett, gave some examples of the sorts of cases that would fall within that top-down approach, where you don't have to interrogate each individual class member to work out what they lost. One example is where every class member was charged wrongly and unlawfully a fixed fee. Again, in that case, you don't need to interrogate every single class member to work out what the total amount due to the class is. You know what the fixed fee was, you know how many class members there were, and you do the maths. Another example cited by the Supreme Court was where every class member bought the same product with the same defect, which reduced its value by the same amount. And again, in that case, you don't need to interrogate the position of every class member. You can work out what compensatory damages are owed to the class as a whole. So you can quite see that there might be a number of consumer claims that fall into those sorts of categories, where the top-down approach is a means by which you can calculate what is due to the class as a whole. So that is where Lloyd and Google, whilst obviously a lot of the press that followed Lloyd and Google commented on how it wasn't a great step forward for the representative action regime, actually properly analysed, the Supreme Court gave us some pretty useful guidance. It's useful both to claimants looking to bring these claims and also obviously parties looking to defend them as to what same interest means. And I think it is probably fair to say that the test is now a much clearer one than we had before, and has obviously provided useful guidance for other cases that are proceeding through the courts.
Thanks, Dan. I think that's really interesting. So I think the the examples that the Supreme Court focused on were very much where you could apply the top-down approach, but actually the kind of harm to each of the members of the class is the same.
That's right. And I think that's where, sorry to interrupt, I mean, that's where, you know, I think it's a great example of the Supreme Court wanting to be very practical. You know, I think there is obviously a nervousness about CPR 19.8, you know, potentially turning us into this sort of, you know, class action regime, you know, call it ambulance chasing, where, you know, all of these claims suddenly get brought. I think the Supreme Court was quite mindful of that. And it was a good example of the court balancing the interests of various parties. You know, clearly we need some sort of representative action opt-out regime, but I think, you know, there's got to be some limits to that rule so that we don't encourage too much litigation, if I put it that way.
Do you think that the regime is still applicable where there are a class of, and you can carry out a top-down assessment, and there are a class of claimants who don't all have the same level of harm? How would the court approach looking at that kind of quantum?
Yeah, I mean, I think if each class member has suffered a different amount of harm, but you can assess that harm on the top-down basis or applying the common method of calculation, I mean, I think in principle you could proceed as a CPR 19.8 case. As I say, if what you have to do is interrogate the position of each individual class member, I don't think you're going to be able to do it. So, you know, in principle, as long as there's that common method of calculation, you may end up in a position where each class member has suffered a different loss. But as long as you can actually calculate that loss without interrogating each position, then I think it's permissible. But there's clearly going to be, you know, a certain category of case, and as the law currently stands under Lloyd and Google, and then under the later High Court decision of Prismail, you know, the court there has said, look, you can't bring claims to recover data breach damages under the CPR 19.8 regime, because that necessarily involves an inquiry involving the participation of the class member as to how that particular data breach affected them. And so you might have some people, I mean, in the Supreme Court judgment, I think the court gave some illustrations of some people who would have been very affected by the data breach and may well have suffered, you know, all sorts of emotional and mental distress. And there might be some other people who, yes, were victims of the data breach, but who were just not affected in that same way. So that's an example of where the court is saying, look, you know, you can't, everybody is necessarily going to suffer a different level of damage. And the only way to ascertain what that damage is to require the participation of the class members, presumably to give evidence as to how the breach affected them. And so those sorts of cases at the moment are looking difficult, where you need that participation of class members. But there are some workarounds. You know, it's not the end of the road for those cases. The first workaround is the one that was identified by Lord Leggett in his judgment, which is that you obtain through the representative action regime a judgment on liability, and also a judgment that grants declaratory relief that damages are payable to the class. So you stop there. You know, you don't get into the question of how damages are calculated. You can't come up with the number that's owed to the class, but you have a declaration that damages are payable. So you would then have to move into a different regime in order to actually calculate what that damages are, what those damages are, both in respect of individual class members, but also to the class as a whole. And you're likely then, because you're going to need the participation of class members, you're likely then to need some sort of book build. You're going to need to effectively sort of recruit claimants and then interrogate them as to how they were affected individually by whatever unlawful conduct caused the harm. That, of course, and again, as Lord Leggett identified, is not such an attractive proposition for a funder, because, as we know, book builds can be time consuming, they can be expensive, and they rarely result in every single class member or affected person actually signing up to the claim. So that can impact on the economics of fundings. But that is a way that you could go, and I think there is a class of case, unquestionably, and I think there's a number of cases that are, more than viable in terms of liability judgments through 19.8, more challenging to get damages calculated through 19.8, but at least you have a liability judgment, and that may well help the later book build in order to recruit claimants and give people an opportunity to collect at the end of it. So that's the first. The second, I mean, you could just proceed on an opt-in basis from the very beginning. In other words, you don't obtain your liability judgment through 19.8. You do a book build at the start, and then you apply for a group litigation order. I think we're seeing that GLOs sometimes are not needed for these types of case. It is one means through which to case manage opt-in claims, but it's not the only one. So the third method would be, again, you sign everybody up in a book build, as many claimants as possible, and you then end up with a bespoke set of case management orders. So you might have concurrent case management and trial under CPR 3.1 brackets 2 brackets H, or you might end up with a sort of an exemplar test claim scenario where out of, for example, for the sake of argument, let's say it's 500 claims, you end up with maybe 10, 15 test claimants, and you have a trial of preliminary issues by reference to those test claims, and you may well then have findings on damages owed to those test claimants. But the idea is, once you've got those findings that they're either binding on the wider group, or they give helpful guidance to the just and efficient determination of the remaining claims, and the idea is that a settlement results fairly shortly afterwards. So, taking a step back, CPR 19.8 is only one of a number of ways that you can proceed in the collective redress sphere. It has the huge advantage, obviously, of needing only one claimant. It also has the advantage of not having to case manage hundreds, thousands, possibly tens of thousands of claims at the same time, which can place enormous burdens on the court, as well as result in very, very high costs. So there is unquestionably a place for the representative action regime, and I think we will see more claims brought through that regime in light of Lloyd and Google. But I don't think many people will disagree with the fact that there are just a certain number of claims that are inherently unsuitable for the representative action regime, and for those you're looking at the opt-in regime, GLO, multiple claims on the same claim form, bespoke case management. There are lots of tools that the court has in its toolkit to deal with those sorts of claims. So it's pretty flexible, and there's a number of options available to potential claimants.
Great, thanks, Dan. And I think, as you said, the attraction of the 19.8 procedure for a funder is that you're capturing the entire class, and you don't need to fund or go through the book build process, and with the risk that has. Just sort of stepping back and thinking about one representative, how do you go about selecting, or what are the characteristics that you look out for in selecting the representative to put forward under 19.8?
Yeah, it's a less formal regime to the competition regime, and many other jurisdictions have a very prescribed process for how class representatives are selected and then confirmed by the court. The English representative action regime certainly doesn't contain any statutory guidance as to how you select a class representative. The way it tends to go is as follows. Firstly, the class representative issues and serves its claim. It obviously identifies itself as the class representative, and a paragraph goes into the particulars of claim, which identifies and informs the court and the defendant or the defendants that it proposes to be the class representative on behalf of a defined class, and the class is then defined. So you start off by pleading your case, and it is then for the defendants to challenge the class representative's attempt to commence the claim as a representative action. And that's where essentially you end up, for all intents and purposes, in a certification process. And of course, there the court will determine whether or not the same interest test is met. So we will go through all of the hurdles that we've just talked about. But the court also has an inherent jurisdiction to allow or disallow the claim to proceed as a representative action. So there's a very heavy discretionary element. And I think it's part of that discretionary inquiry that the court will consider whether this representative is suitable. And clearly they need to be somebody who is able to represent the class as a whole, represent the class and act in its best interests. Have they got a proper legal team? Is this somebody who can, run the litigation effectively? I mean, it's a big responsibility to run litigation. So in practice, whenever there is a challenge brought to a 19.8 claim proceeding, usually evidence is served both by the claimants and the defendants as to whether or not this class representative is suitable, and the court will determine that as part of its discretionary inquiry. And if the answer is yes, I am content that this representative may represent the class, then it is, for all intents and purposes, certified as a class representative. Not formally, there's no formal certification process, but the court grants an order that the claim may proceed as a representative action, and then away you go. You have then litigation brought and permitted under CPR 19.8, and you'll be heading into your first case management conference, and the usual directions will follow.